So how quickly must a public office respond to a public records request? The Public Records Act says that public records must be promptly prepared in response to a request for inspection, and copies must be available within a reasonable period of time. The Supreme Court has said that promptly and reasonable period of time depend on the facts and circumstances surrounding the request and your office. Promptly and reasonable period of time include time to identify and retrieve responsive records, review them, obtain legal advice, and redact if necessary. What is reasonable or prompt will be different depending upon the particular request and the volume of the records requested. Take, for example, the difference in responding to a request for a recently issued press release and an old litigation file. A recently issued press release should be fairly easy to locate, and because it was already issued to the press, it should not require legal review or redaction. In that situation, one would expect a fairly quick response. But an old litigation file may be stored at an off-site storage facility, and it may take a few days just to retrieve the file. Then, because it is a litigation file, a careful legal review will likely be necessary for things like attorney-client privilege and trial preparation records that are exempt from disclosure. One would expect a much longer period of time to respond to the litigation file request. For example, in the Ohio Supreme Court case Patton v. Rhodes, involving a public records request made to a county auditor's office for the county's financial reports for 4 years. At the time of the request, the audits of the financial reports had not yet been completed by the state auditor, and there were potential claims by various federal and state governmental entities which were preventing the completion of the audit. As a result, the public office delayed responding to the request in order to seek advice from the state auditor about whether to release the requested financial reports. Approximately 56 days passed from the date of the request before the county auditor released the financial reports. While the requester argued that this was not a reasonable period of time, the Supreme Court held that in light of the facts and circumstances, including the ongoing audit of the financial reports by the state auditor, 56 days was not an unreasonable period of time to respond to the public records request. In another Supreme Court case, DeFranco v. South Euclid, the requester asked for a long list of financial records associated with several city-owned properties, records disposal forms, records showing legal spending for a 9-year period of time, and records of overtime payments for 8 months of a particular year. While the city produced a number of the records the requester was seeking, it did not produce several categories of records. In fact, the city did not produce the remaining records until the requester filed a lawsuit, 8 months after the request was first made. The court found that this delay was not due to reviewing the records, but instead an inadvertent omission of these records from the city's earlier response. And in considering the facts of this case, the court found that this delay was not reasonable. It is important to remember that promptly does not necessarily mean immediately. Reasonable period of time does not depend on a reporter's deadline or an approaching trial date for an attorney. Rather, these terms mean that an office has the time it reasonably takes to provide the records, which might necessarily include tasks like gathering records, reviewing them, and then sending them out. While public office cannot delay responding to a request or put it on the back burner, remember that there is no set number of days to respond to a request in the law. However, a public office may want to negotiate with a requester which parts of a request are most important or time-sensitive, and do your best to respect their timing needs as a matter of courtesy. In order to comply with the requirement to provide copies of records within a reasonable period of time, a public office may want to respond to parts of requests on a rolling basis, meaning delivering to the requester an individual set of public records as soon as it is reviewed and available for release. For example, if a request calls for 1,000 pages of documents, perhaps it makes sense to work with the requester to either narrow their request or to have the requester help you prioritize your response. This way, you send records as they are available, and the requester might be satisfied before you get through all 1,000 pages. Rolling requests are often a win-win for requester and public office, so consider that strategy when you're faced with a large request. Just remember, if a public office ends up in court, it bears the burden to show that it did not allow any unreasonable delay in processing the response. Every public office must adopt its own public records policy under the Act. This is a duty, but it is also an opportunity for you to educate both your employees and public records requesters about public records requirements. You only have to write it once, so do it right in plenty of detail, and it will keep working for your public office wherever it is posted. A well-written policy can educate requesters about the agency's processes and responding to public records requests. A good policy can save a public agency time in answering questions. The Attorney General's office is required to provide a model public records policy, which is a good place to start when an office is drafting or editing its policy. This model policy is available on the Sunshine Laws page of the Attorney General's website. This policy includes provisions that we have found helpful in explaining to the public our office's policy for handling and responding to public records requests. For example, the Attorney General's policy requires that all requests for public records should be acknowledged in writing or, if feasible, satisfied within 3 business days following the office's receipt of the request. Why is this helpful? It tells the requester we have the request, that someone is working on it, it identifies a point of contact, and confirms the scope of the request. This policy also makes clear to the requester the Attorney General's time frame for responding to requests by noting that the availability of records for prompt inspection and the availability of copies of records within a reasonable period of time takes into account the volume of records requested, the proximity of the location where the records are stored, the necessity for any legal review and redaction, and other facts and circumstances of the records requested. It is important to keep in mind that a public office should not just copy and paste the Attorney General's policy. Instead, a public office's policy should be specific to the way in which that office's records are kept and maintained. The policy should also contain information that would be helpful to a person who is making a public records request to that public office and just doesn't know where to start. The best policies do not have to be incredibly lengthy and detailed. They just have to give the requester the information he or she would need to make a public records request to that specific public office. The Public Records Act outlines some specific things that public offices must do with this policy. For example, the agency must distribute its policy to the employee who has custody of the office's records and require that employee to acknowledge receipt of the policy. The agency must also include the public records policy in any existing general manual of policies and procedures, and it must also create a poster that describes the policy and post it conspicuously in the office and all branch offices. The purpose of these requirements is to ensure that the employees of the public office and the people responsible for responding to public records requests are aware of their obligations under the Public Records Act. The law also outlines certain provisions that cannot be included in a public office's public records policy. First, the policy may not limit the number of public records that the public office will make available to a single person. So, for example, you can't have a policy that says, any single requester that comes to our office can only request up to 500 pages of public records a year. That policy would improperly cap a citizen's access to the public office, which is unacceptable under the public records law. This is because the goal of the Public Records Act is to promote transparency and openness, and public offices policies should not be used to impose quotas and hinder a requester's ability to obtain public records. Second, the policy may not limit the number of public records that it will make available during a fixed period of time. So you can't have a policy that says, this office will respond to any and all public records requests, but will only provide 500 pages of documents per week, and then no more until the next week. Again, that would improperly limit access to that public office, which does not serve the purpose of the public records law. And third, the policy may not establish a fixed period of time before a public office will respond to a request for inspection or copying of public records unless that period is less than 8 hours. The purpose of this prohibition is to ensure that public offices do not backburner public records requests and reinforces the requirement that requests for inspection should be honored promptly and copies of records are provided within a reasonable period of time. Legislative changes to the Public Records Act also identify a number of things that the public agency may include in its policy. Specifically, the agency may limit the number of records provided to a person that the office will physically deliver to 10 per month, unless the person certifies to the office in writing that the person does not intend to use the requested records of the information contained in them for commercial purposes. The agency may also limit to 10 per month the number of records requested by a person that the office will deliver in digital format if the office offers its records on a website that is fully accessible to and searchable by the public free of charge, unless the person certifies in writing that the requester does not intend to use or forward the requested records of the information they contain for commercial purposes. The term commercial is narrowly construed and does not include reporting or gathering news or nonprofit educational research. Again, a public office should remember to post and distribute its policy wherever it can save time by providing useful information to requesters and employees.